More insight on the U.S. terrorism watch list. Joining us from North Carolina is Martin Reardon. He's a 21-year veteran of the FBI and served as chief of the FBI's Terrorist Screening Operations Center. Mr. Reardon, thanks for joining us. We've just heard a great deal of criticism about the manner in which the watch list is handled and the way it works and the fact that it's in many instances so ineffective. There are people who have nothing to do with terrorism whose names are on the list, and then we have people who've been asked to spy or inform on their communities, and when they refuse to do that, the FBI puts them on the watch list. So what is the criteria that the FBI uses to put people on that list?
Criteria is fairly straightforward. It's an accepted legal standard within the American justice system of reasonable suspicion, which is nothing more than specific, articulable facts taken together with rational inferences of those facts that would lead a reasonable person, and reasonable is important, not a judge, not an attorney, not a police officer, but a reasonable person to believe that an individual in this case is a known or suspected terrorist.
Well, let's look at a particular case.
Or may be a known or suspected terrorist. All
right, let's look at some particular cases. We have the case of 4 men who were put on the list because they refused to become informers on their communities for the FBI. We have a case of a Malaysian woman who was put on the list. She fought the case. In fact, she's the only one who has successfully legally got her name taken off the list. We had Senator Ted Kennedy's name put on the list. The Bolivian president, his name was put on the list. We had a 2-year-old whose name was put on the list. So how effective is this system?
Well, it is an effective system, but I think it's also important when you look at the numbers of individuals who are on that list. This is a small percentage where we're having problems. But to take each of the examples that you had listed, the 4 individuals who are claiming that they are basically coerced into being FBI sources or informants, and because they refused to do that, were put on the list. I don't believe that one bit. That's not the way the FBI
Okay, if you don't believe that, isn't the best way to resolve this for this to go to court? And there, all the information will come out, and then a judge can make that decision.
I know that's the stance that the ACLU and a number of people take. The problem with that, and I think Attorney General Holder spoke very well on this, his declaration earlier or late last month in district court. 3 reasons why, in matters like this, we push for the state secrets privilege. First of all, to identify a subject, we would either have to confirm or deny that that person was the subject of an investigation. GLOMAR response that the United States has been using since at least the mid-'70s, we don't do either one of those. The second, and more importantly, is it would require us to state the predicate for that investigation. What was it that happened that led us to opening that intelligence or that, in this case, counterterrorism investigation? And then finally, it may force us to reveal sensitive sources and methods. A lot of the information that is used to open up these type of cases, it comes from foreign government information, it comes from sensitive and classified techniques. It could come from confidential human sources that are used within the U.S. intelligence community. So it's a risk of jeopardizing those sources and methods or the reason that the investigation was opened in the first place. Keep in mind, too, at this point, or people on these lists, these are generally ongoing investigations. In most cases, a decision has not been made, or you have not reached a point in that investigation where you can bring charges against those individuals. This is a way to keep them from flying while the investigation is ongoing.
But doesn't this work against the fundamental principles of United States justice? I mean, this is a country that professes to be a democracy, where the rule of law is paramount, where people have legal recourse, where we have due process. All that is swept aside.
No, I disagree with that. You're right. Our fundamental rights, civil liberties in the United States are very important. The Terrorist Screening Center has an entire unit of attorneys who look at everything that is done to make sure that we maintain that delicate balance. One, protecting the homeland from attack. Also, just as importantly, protecting the civil liberties of Americans and non-Americans alike.
What about the case of the young Nigerian who happened to get onto a plane when this list was in operation, a plane that was bound for the United States with explosives? He was overpowered by people on the plane. I mean, the system didn't work then.
Well, you're right. In that case, it didn't. Abu Muttalib, Christmas of 2009. That was a vulnerability that was identified. He was not properly watched, or he was not watch listed at all. And I think that's what led to that big surge in late 2009, early 2010, of putting additional people on the watch list. It's not a perfect system in any stretch of the imagination, but it does work.
Martin Reardon, we're going to have to